Ceann Comhairle. Ceann Comhairle, this bill seeks to extend the powers of audience that members of Garda Síochana have before the District Court. And although it is a very short bill, its brevity shouldn't disguise the fact that there's a very complex and lengthy history to the rights of audience that police officers have had before our courts, particularly for minor offences. Prior to independence, it was the case that in respect of all minor offences and some indictable offences, members of the RIC, the constabulary, were the people who were able to give evidence before the courts. The reason they were able to give that evidence was not because of any statutory power that they had, but because they had this common law power to give evidence as common informers. The reason they were common informers was because they were members of the public and they were in a position to give this evidence before the court. That was a very widespread practice before independence. In fact, it became too widespread and there was criticism of police officers, as they then were, for effectively becoming advocates before the court. In Ireland, it was slightly different. In Ireland, the law officers encouraged it, and in fact, there were statements to members of the RIC that they should, in fact, examine and cross-examine witnesses and, in effect, be witnesses. After independence, all the prosecutorial powers were transferred to the Attorney General of the Irish Free State under the Criminal Justice Administration Act of 1924. And in Section 9 of that Act, it set out how the powers of prosecution were to operate in respect of indictable or serious offences, but also in respect of minor offences. And when you look at Section 9(2) of that Act, it's clear that the power of members of the constabulary to prosecute as common informers continued, and it was transferred over to what was then the new force on Garda Síochana. So the power in this new state for members of Garda Síochana to prosecute as common informers continued. It also continued even after the establishment of the office of the DPP in 1974, and even though there were many offences that were prosecuted at the suit of the DPP, and before him the Attorney General of the Irish Free State, predominantly Gardaí were prosecuting as common informers. I suppose the time we got full recognition on that and a better understanding of it was back in 1977 when there was a Supreme Court decision in the case of DPP against Roddy. And it was in that decision that Mr Justice Griffin stated that Gardaí who are prosecuting as common informers. He looked at Section 9 of the Criminal Justice Administration Act 1924 and he noted that the power of Gardaí to prosecute as common informers hadn't been removed. I suppose the reason we are all here today is because of the recent decision of Ms Justice Bulger in the High Court. It's important we're aware as to what happened and why that case was stated to her for her consideration. It related to a minor drugs prosecution in a district court. A guard was there prosecuting, but the initiating guard, the guard who had arrested, the guard who had brought the case, wasn't in court. But the replacement guard was there, and the replacement guard wanted to be able to give evidence if the accused pleaded guilty or wanted the case to be adjourned if that wasn't the case. And the district court judge was asked by the presumably solicitor representing the accused if she would state a case. She did state a case, and the case was whether or not the replacement guard, the substitute guard, did have a right of audience before the district court in respect of that prosecution. Ms Justice Bulger answered it, and she answered it in the negative. She said there was no right of audience. The reason she did this was she looked at Section 8, subsection 2 of the Garda Síochana 2005 Act. And that was the legislation that in effect removed or codified the common law. It provided a statutory basis upon which the Gardaí could prosecute minor offences in the district court. That was something that had been recommended by Mr Justice Griffin in the case from 1977. But when you look at Section 8(2), it's very clear that it says that any member of the Garda Síochana may institute and conduct prosecutions in a court of summary prosecution, but only in the name of the Director of TPP. I suppose here sometimes we think we get too worked up about words that are contained within legislation. But in fact, the reason we're all here today introducing new legislation is because the word "and" was used in that section. Had the word "or" been used, we wouldn't be here. And in the case before Ms. Justice Bulger was argued by the State that the section should be read disjunctively. Now, I don't think that makes any sense, because whoever was here back in 2005, clearly when they used the word "and," they meant to use the word "and." Had they meant to use the word "or," they would have used the word "or." And those of you who have read the decision of Ms. Justice Bulger would see that she very correctly assessed the language contained within the statute and said that, listen, if the Oireachtas was going to be deliberate in changing how prosecutions are done in the district court, well, then it clearly would have used very precise language. And she rejected the argument that had been put forward by the State that, in fact, you should read it disjunctively, and in fact the word "or" could be substituted for the word "and." Listen, obviously it has significant consequences, and that's why we're here. And I want to commend Minister Brown for bringing forward this legislation so promptly. I think it is an example of where legislation needs to be brought forward promptly. There's a whole series of prosecutions that are going through the district court throughout the country at present, and we don't want to find ourselves in a situation where every initiating guard has to be in the district court on a particular date, otherwise the proceedings are going to be struck out. That would be a miscarriage of justice itself. But I suppose we do have to go back to what was contained within the Commission on the Future of Policing's report. It recommended that we need to get the Gardaí out of court as much as possible in their capacity as presenters. It's a waste of time for Gardaí to be in courtrooms, sitting there, ultimately becoming advocates in the district court. None of us want to see that. We all want to see Gardaí out on the street fighting crime as opposed to presenting cases. Obviously, Gardaí are going to have to be in court in order to give evidence as witnesses. But that's different, I suppose, from the whole issue of court presenters. So I'd welcome, Minister, if in the future we can bring forward legislation to give effect to the recommendation of the Commission on the Future of Policing. We want to see presenters in court. We don't want to see the rules of evidence cut short. Obviously, direct evidence will have to be given by Gardaí who spot things at a particular occasion, but I do think this legislation is necessary. Thanks, Garda.